carries a maximum sentence of death, she invited court to look through the following while considering the sentence. One, that the convict is a police officer, well trained and of a high rank, who knows that the wife and he's the sole breadwinner for the family. It submitted further that the convict has a medical condition with an implant in his knee and walks with the help of a blood. He prayed for a lenient sentence so that he can go back and is given an opportunity to reform, get back to the community and take care of his family. When the convict was given an opportunity to address court before sentence, he said he will only the time was released on bail. He did not manage to sort out his problem with his hip, which has an implant and is not yet settled. He also prayed for the record of proceedings and judgment. I have considered the submissions from the state attorney in Allocatus and the Land Defense Council investigation. I have also considered the address of the convict before sentence. Section 189 of the Penal Code Act prescribes death as maximum sentence for murder. This court is guided by the Constitution sentencing guidelines for courts of education practice directions 2013 when it comes to the factors that aggravate or mitigate a sentence. Regulation 20 of the same guidelines provides for the considerations court should follow while considering a death sentence, which include the gravity of the offense and violence involved. This court is further bound by the case of Attorney General versus Susan Chigula and 417 others, Constitutional Appeal number 3 of 2006, where the Supreme Court decided that the death penalty, though constitutional, was not mandatory but discretionary. This Chigula case changed the sentencing regime in Uganda, giving the trial judge latitude of determining the sentence depending on the mitigating and aggravating factors. The High Court now has wide discretion ranging from imposing the death penalty, life imprisonment, for a number of years. In this case, apart from being a first offender and a person with some disability, court has not found any mitigating factors. His disability did not prevent him from committing the heinous crime. This court has therefore not considered it as a mitigating factor. The primary function of sentencing is the imposition of an appropriate punishment for the criminal conduct. It is the duty of this court to impose a sentence that will have the effect of maintaining a just, peaceful and safe society. This would ultimately preserve and promote the rule of law. The convict, who is a police officer at the rank of Inspector of Police, killed an innocent child in the most gruesome and barbaric manner. The photograph of the child with a police lanyard tied so tightly around her neck was so cruel. His conduct is not only abhorrent, it's disgusting, but an embarrassment to the Uganda police force that is trained and charged with the statutory duty of protecting lives of Ugandan citizens. His victim was just an innocent, defenseless child of 9 years. Much as he was walking with the support of one black tie, around her knee so tightly that she could no longer have supper to her brain. She died in a very short time, but very painful death, as she saw Amendment Act of 2019, which defines life imprisonment, among others, provides that for purposes of any enactment, prescribing life imprisonment or imprisonment for life. Life imprisonment or imprisonment for life means imprisonment for the natural life of a person without the possibility of being released. Part 2 says, notwithstanding section 1, a person liable to imprisonment for life or life imprisonment may be sentenced for any shorter term of imprisonment, not exceeding 50 years. But because the convict has no previous record, court is not passing a sentence of death or life imprisonment, matters that is what he deserves, given the breach of duty as a police officer and the manner in which he killed an innocent faceless child. The sentence should, however, be aimed, among others, at denouncing the unlawful conduct, deterring the offender from committing crime, and deterring other would-be offenders. The convict has not exhibited any remorse at all, as he is more concerned about himself and his family. The attack of the innocent child was so ferocious, exhibiting the convict as an animal in a human body. A ferocious animal is domestic, is caged, and if wild is avoided at all costs. How should courts of law deal with a ferocious convict like IP Abura Emmanuel Wilson? Ability as a tool to attract sympathy, yet behind his disability is a savagely fierce human being who needs to be kept out of circulation for some time to enable him to reflect on his life as a human being and work on his inner soul. He has no regard to other human beings. He lives to tame his inner man. He remains afraid to people around him who may cross his path, especially the vulnerable children. Article 23, Article 8 of the 1995 Constitution of the Republic of Uganda requires this court to take into account the time the convict spent in lawful custody at the time of sentencing by deducting the pre-trial time from the sentence imposed. He was first remanded on 17 November 2021 and released on bail on 27 May 2022. He therefore spent 6 months and 10 days on remand. His bail was cancelled on 28 March 2024, sending him back to remand until 8th of May 2024, which is today, which is 1 month and 11 days. The total time spent on remand is therefore 7 months and 21 days. Considering the gravity of the offense of murder, the manner in which it was executed, the need to protect children who are the future leaders of tomorrow, and the importance of deterring others from engaging in similar criminal conduct, the convict is sentenced to 50 years imprisonment, less the period he has spent on remand, which is 7 months and 21 days, leaving him with a period of 49 years, 4 months, and 9 days to be served subject to remission. And is free to appeal against both the conviction and sentence within 14 days from today if he is not satisfied.
Kibonerezo ekiweereddwa omusilikale yatta Mwana.
Amanya gange bamutata akalize ekibonerezo kibadde omusajja yatta omwana wange ndaba kitono kubanga owange tagenda kumawo yagenda sigenda kudamu kumulaba yagenda kuvayo ataddaana nga nzita agivayo akomewo nanga nzita yasigala tuwoninga bwe bamubakoti beiro yali nga tuwoninga straight zibadde nga straight nga bajja balinya ekikkomera bagala tukuba kiro twebaka mu nnyumba tutulawa neiba twajja ne tukomplaininga ku high court kwanza fayiro nerabika fayiro yali ebuze nga bagicyankalanya yonna tu statement zaffe ne zibulagana mu fayiro complainant yawaaba ne bajja mu statement ze zonna era ne tuddamu kuwabupya statement emba omwami omulaba kukyala ayongera agamba baali bagala sente bali bagala sente nenga atambula nezija ku high court wano ninkabira w'amaziga nebagamba munyambye mutya omwana wange yafa omusajja agenda kunsita nange sebagamba bagenda kunoonya fayiro oluvannyuma ne bagizuula nti alimu akayizi tebagizuula omusango ne gutandika ne kati nze simatidde musajja ono yabadde asana kufa ng'omwana wange yafa